The government wants to sail between the Scylla of the Sixth Amendment and the Charybdis of the Seventh Amendment. And it seems to think that it can escape the Seventh Amendment by listing 42 things that would be inapplicable in any other situation. But either of those would destroy this regime, probably. So why should which one is more dangerous?
The Sixth Amendment is by far more dangerous. Let me give you a quick pitch on the dig, though, for that, which is that this is the lurking issue that actually really matters here, and the parties have barely briefed it. The actual question presented is vanishingly unimportant for people who were committed the crime before April 1996, were convicted after. For some reason, the court applied the MVRA, even though the government was saying to apply the VWPA, and they still have an outstanding award. So the actual QP is not very important. As you say, though, the jury trial question could destroy the whole regime. So under the Sixth Amendment, the Apprendi rule, as elaborated on in Southern Union, says any fact necessary to increase the maximum monetary award, I'm going to sub in monetary award, but the court has applied that to fines, requires a jury trial. Lower courts have said in this context that, well, the conviction authorizes the maximum unlimited amount of restitution. As Justice Gorsuch pointed out in a separate opinion in Hester, I mean, that just does not follow logically. Under 3664E, the court
Thank you, Mr. Bash.
Under 3664E, the court has to find by a preponderance of the evidence that particular items of loss have been proved. Clearly, that's fact-finding. For any non-zero amount of restitution, the Apprendi rule would obviously require a jury trial. Of course, the court could always draw exceptions to it. Justice Alito, in the same case, you suggested maybe just kind of drawing a line there, but the Apprendi rule clearly applies under the Sixth Amendment. The Seventh Amendment is much closer to me. So on the original understanding of the Seventh Amendment and its plain text, it says suits at common law. So I think pretty clearly this is not a suit at common law. It's a statutory restitution proceeding. Of course, this
court has said, Mr. Bash, as you are well aware, maybe about to say, and
I'm not going to stop
there,
Justice Gorsuch. I got more riffs on that.
I'm sure you do. I know. But the court has said, labels don't matter. And if it's in substance a civil trial for restitution, that would have been a suit at common law. Surely, wouldn't you agree?
So what this court has said is that statutory causes of action that mimic common law causes of action, both in substance and in remedy, meaning the Beacon Theater's damages, equitable distinction, trigger the Seventh Amendment right. So let's just accept that the court would not reconsider that. This is not quite a statutory cause of action. It is sort of an unusual proceeding, although the one that had a history behind it at common law, as I think your opinion pointed out. But here's what I think is the important point. This court has been much more context-dependent on whether the remedy phase of a civil trial requires a jury finding. So the two cases are Tull versus United States and Feltner versus Columbia Pictures. In Tull, the court said, I mean, this was in a footnote, but the majority said, we see nothing in the Seventh Amendment that requires a jury trial for the remedy phase. And that was a civil penalty where it was very discretionary. In Feltner, 9 years later, copyright damages, the court said that requires a jury trial. But part of that was based on the unique history of the Copyright Act. So all I'm saying is I think there would be historical work to do under the Seventh Amendment. The Sixth Amendment, unless this court really drew a kind of outlier exception to Apprendi, I think the Sixth Amendment case is pretty open and shut.
Isn't that interesting that here you're making an argument that the government has miscalculated its own interest in choosing to take the risk with the Sixth rather than the Seventh?
It does that sometimes. And frankly, I think that
the government's made its bed. Why should we let them lie in it, Mr. Bash?
Well, there is a path-dependent reason, I think, for that, which is that the government developed this position pre-Apprendi. And so it developed this position that restitution is criminal. I'm reading between the lines.
It made the opposite argument in the Eighth Circuit, and here we are. It's flipped its view.
Yeah, I think maybe the U.S. Attorney's Office there didn't follow the DOJ position overall.
And it's admirable that the DOJ flipped its view, I want to say. I think it is admirable that they reconsidered their position, but they've made their judgment.
And all I'm saying with respect to their analysis of the jury trial right is that they developed that position pre-Apprendi, I think, precisely in order to avoid the Seventh Amendment problem. The problem now is, I think, arguably the bigger constitutional problem is the Sixth Amendment. And I didn't hear, in response to Justice Kavanaugh's question, a very satisfactory explanation of what the court would say in this opinion to avoid the Sixth Amendment problem.
Thank you.